So this is on the secondary petition filed on behalf of the petitioner, Mrs. Bianca Dewees, previously Humphreys, and it is a motion to modify or to strike an alimony pleading. And I filed a motion to dismiss for failure to state a claim upon which relief can be granted. I've set forth in my motion the reasons for that. As the court is aware that marital dissolution agreements, especially granted on the grounds of irreconcilable differences, are contractually binding. And again, this is the term of transitional alimony. Transitional alimony is not modifiable unless specifically under the stated under the statute, and I've set forth in the body of my motion the language found in Tennessee Code Annotated 36-5-121 subsection G. And as a result, if Your Honor will look at the petition filed to terminate, the only allegations are basically, if we can say, buyer's remorse, alleging that circumstances at the time of the divorce when it was granted back in 2020 would not have rose to the level of a granting of transitional alimony. But again, Your Honor, this was a divorce on the grounds of irreconcilable differences, and a marital dissolution agreement was adopted at the time. And again, the language contained in the petition does not meet the statutory mandate for a modification, for which we would ask that the petition be dismissed.
Your Honor, I would ask one, to start, I'd ask to take leave before we amend the petition. Although I believe that the underlying petition in and of itself and the marital dissolution agreement violates public policy, base of it, I would ask to take leave of the court in my petition to add in an additional fact that suffices under the statute.
All right, stand in front of that microphone and tell me what exactly it is that you're wanting to amend.
Your Honor, I would like to amend the petition to terminate alimony. Under the statute, there is a presumption in the statute that it would be terminated when they reside with a third party. I can add in that additional fact as he does reside with his fiancée now, although I believe that we would argue certainly that, but I believe the underlying marital dissolution agreement, the portion of the alimony, I believe, violates public policy, as on the face of everything in that divorce. She was the economically disadvantaged spouse, and therefore I'm not sure how she is the one paying alimony when the court has jurisdiction to strike a provision of any contract that violates public policy.
So you're wanting to set aside the entire divorce, huh? Because that's the net effect of what you're asking to do, because it is a divorce that was granted on the grounds of irreconcilable differences. And because of that fact, if you're saying that the agreement violates public policy and therefore should not be enforced, then the entirety of the divorce decree would be invalid and would not be enforceable, and therefore they would be back in the stage of being married.
Well, I think, Your Honor,
just making you aware of the significance, as I see it,
yes,
of what it is that you're arguing as far as the public policy.
I understand that. I believe that the marital dissolution agreement in most have a severability clause where we could strike a portion of the marital dissolution agreement while
Not when it's an irreconcilable differences divorce. The statute's very clear in a marital dissolution agreement on the grounds of irreconcilable differences. All issues, and I've had some personal experience with this as an attorney practicing in my early days, where the Court of Appeals vacated a ruling by Judge Robert Birch that I was involved in, because no one had raised the issue about whether or not the parties hadn't agreed on everything. We agreed on the property division and submitted to the judge a divorce on the grounds of irreconcilable differences and let him decide the custody issue. Nobody raised that issue except the Court of Appeals, who said by statute you cannot have an issue that is not resolved by an agreement. And if you have an issue that is not in total agreement, then the divorce cannot be granted on that grounds. They vacated our divorce even though neither one of us wanted that. So I'm just telling you that's
right.
I think that's pretty clear that the law has remained that way in the last 30 or 40 years since that case took place. But But I understand your argument, but I just am simply saying that that significance of that argument may also be, may contain ramifications that are not necessarily what either party wants.
I understand, Your Honor. But if I may just take leave of court, I'll amend my petition to factor in the statute provision of that, and then we can just set it for hearing and go from there, I believe.
Your Honor, if I could, I don't have an issue if counsel wants to amend his petition, but I do have an issue if we're proceeding on the grounds that are still alleged in there. Again, I think I have clearly put out in my motion the basis of the factors that are necessary. And again, as Your Honor said, I cited the grounds of irreconcilable differences is that each and every provision has to be agreed on by the parties for the court to grant that divorce. So if now they're seeking some 5 years hence the granting of the divorce, then again, they have to proceed under a Rule 60 motion. And given the time limit that is lapsed, we have a statute issue unless they can prove some type of a fraud or something from that standpoint. And none of that is alleged in the petition. And so this is a contractually binding agreement. Now, and again, as it states in the statute, an alimony recipient lives with a third party in which case a rebuttable presumption is raised. One, the third party is contributing to the support of the alimony recipient, and the third party or is receiving support from the alimony recipient. So again, that's not alleged in this petition. So again, if they want to, if Your Honor grants my motion to what I would request respectfully is Your Honor to grant my motion to dismiss the petition based on the fact that as it is right now, that it fails to state a claim upon which relief can be granted, but grant relief within a certain period of time, 15 days, for them to amend the petition to allege alternative grounds. But the grounds that are stated right now, again, there's not a basis of voidability against public policy. Again, it's a contractual matter. There's no constitutional issue raised in this case. Each party is free to contract in any way they want. And for a provision to be void against public policy, then they would, again, as Your Honor has said, if it is void, then the divorce is void. Their marital dissolution agreement is not granted. Their parenting plan is not granted, which then puts me back in a situation because I first filed the petition to modify the parenting plan. And so I need a ruling on whether or not it's the voidability or the voidness of this agreement, because again, I have an obligation now to come before the court and to prove a significant material change in circumstances. If Your Honor is going to take the void against public policy, then it's a new petition on the divorce, on the custody matter, and we're not bound by res judicata. We can come back in and allege in the custody matter that this is a new case, and we don't have to prove a significant material change in circumstances. So it bleeds over into my case on what Your Honor does on this ruling.
You know, I knew when I woke up this morning that it was Monday, so.
Raining and Monday.
Yes.
All right. I'm going to grant the motion to dismiss based on the grounds that are set without prejudice to the petitioner to file a new, I mean, this is granting your motion based on the grounds that are alleged because there's no allegation that meets the statutory requirement, but I am doing so without prejudice to Mr. Daniels filing an amended petition to terminate alimony that he alleges a grounds that the statute permits, or if he wants to raise the grounds of public violation of public policy, then I'll allow him to raise whatever he wants to.
Yes, Your Honor. Thank you.
Thank you, Your Honor. That's all I have today, if I may be excused.
You may.
Thank you.